23 CR 3546, State of Texas versus Larry Casillas. Can I have parties announced for the record for the state?
Thanks to the state of Texas.
Defense?
Elizabeth Russell for Larry Casillas.
Are you Larry Casillas? Counsel, have you received all the discovery? Did you review it with your attorney?
I have reviewed.
I'm sorry, with your client.
Yes, Judge.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? That appears to be a yes.
That's it. We're proceeding on count one.
All right, there's only one count in the indictment.
Yes.
All right. Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault of a pregnant person? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, we can go off the record. I'm looking at this plea bargain agreement. And there's to be no harmful or injurious contact with Stephanie Ortiz.
That's her by her request, Judge.
I'm not following. I'm not going to follow that.
Even though that's her request.
No, I mean, no, even though it's a request, according to what I'm about to receive, he is a person who is hitting on, not in a loving manner, a pregnant person. I mean, was she pregnant at the time?
Yes, Your Honor.
So if, you know.
She's requesting, and I'm sorry, Judge, may I speak?
Sure.
She's requesting it for her convenience. They've been doing custody exchanges for the last almost a year through a third-party person, and it's her request. She reached out to me, filled out an affidavit of non-prosecution, and requested that. So
I'm not following that. So if you all want to withdraw your plea now, you can, but I am not doing a no harmful or injurious contact for somebody who's accused, and I haven't read the steps yet, who's accused of hitting a pregnant person.
that's fine, Judge. They're no longer in a relationship. The only relationship is for the benefit of their children. He has no interest in communicating with her beyond that.
All right. So I'm not going to follow that. So y'all have a choice. Either you can go to jury trial or either you all can change that part of your plea bargain agreement.
We're proceeding with the no contact, Judge.
All right. If you all want to change that. Court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, we would just request that you follow the agreement between the state and defense. Mr. Casillas is wanting to move forward in a direction that's appropriate for his children. He understands what went wrong and he wants to take full responsibility for that. And he has had no issues since the arrest on this date, and they have been successfully co-parenting since that time. There was a CPS case, Judge, that was closed out for no finding.
All right. How old are you?
21, Your Honor.
How many children do you have?
2, Your Honor.
What are their ages?
1 year and 6 months.
1 year and what?
1 year and 6 months.
Are you employed?
Yes, Your Honor.
What do you do?
I work at Amazon at Facility Warehouse.
All right. So why do you keep hitting on Stephanie Ortiz? At one point, I'm assuming you loved her because you have children with her.
Yes, Your Honor.
So why do you keep hitting on her?
It was just me not being in the right state of mind, me letting my feelings get to myself and not just thinking right and thinking straight.
That makes no sense to me.
Your Honor, it was just my fault. I let my feelings get to myself, let her get in my head and
Let what?
let her get in my head, and I just reacted in a wrongful way.
No, but I mean, you're up here hitting someone. Honestly, I don't even know why I should follow this plea, but your attorney is telling me that she's filed a affidavit of non-prosecution. But according to this, she was pregnant and she was going to be induced that day, and you decided to put your hands on her. I don't understand how is she getting in your head that you would be hitting a pregnant woman who's about to deliver your child.
No, Your Honor, what that day was in the day we were supposed to get induced. But I believe the hitting was before that. So it was just the marks that had came about.
But you still hit her while she was pregnant and she was close to her due date. Not that it's appropriate to hit anyone anyway.
No, it's not, Your Honor.
But obviously she was pregnant.
This courtroom hearing begins like many others. until the judge looks closer at the plea deal in front of her. The defendant is charged with assaulting a pregnant woman, a third-degree felony carrying up to 10 years in prison. Despite an affidavit of non-prosecution, the judge is visibly troubled. She refuses to follow parts of the agreement, making it clear that domestic violence, especially against a pregnant partner, will not be brushed aside for convenience. What follows is a tense exchange, as the court challenges the defendant's behavior, his excuses, and his understanding of responsibility. And as this hearing unfolds, it becomes clear the judge is determined to send a message that actions like these carry real and lasting consequences.
Say that because they knew nobody had a fire for them to walk through.
Mhm.
But I believe you when you say you love your daughter.
Yes, Your Honor.
So how would you feel if your daughter became of age and she ends up with somebody like you who hits on her? Would you be okay with that?
I'll be very upset, Your Honor.
And so your daughter is learning what it means to show love is to hit on people, and might makes right.
Your Honor,
You're going to have to change your ways. You are not to have any contact with Stephanie Ortiz. And anybody else you get into a relationship yet, don't let them meet your publicist. Let them meet you and tell them, hey, want to let you know I had this abusive acts in my background, because then they can make an informed decision about whether or not they want to date you. You understand?
Yes, Your Honor.
All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with Stephanie Ortiz. There's to be the BIPP course, parenting classes. That can be with rainbows. There's to be 200 hours of community service restitution. That will be waived once he completes parenting classes. Regular reporting by Zoom or in person. Regular UAs. If you're drug tested today, what are the results going to be?
Positive, Your Honor.
And what are you going to be positive for?
No, negative, Your Honor.
Negative? Okay. So you haven't used anything.
No,
I think Amazon drug tests, do
yes,
they
yes,
not?
I'm done, Judge. Yes, ma'am.
All right, there's to be regular UAs. I'm going to want field visits one time every 3 months. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. Probation, is there anything else he needs?
You already did mention the regular.
Yes. All right, is there anything else you need from the court in order to be successful?
No, Your Honor, thank you.
Showing you what's calling 2023 CR 2528 and 2023 CR 2529, State of Texas versus Berleo Marquez. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Robert Maurer for defendant, Your Honor.
And are you Mr. Marquez?
Yes, ma'am.
Counsel, have you received the discovery in each of these cases, and did you review it with your client?
Yes.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, in each cause number, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented in each cause number?
We are, Your Honor.
Mr. Marquez, in each cause numbers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
Did you understand in each cause number, you're charged with the offense of aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Mm-hmm.
After reviewing State's Exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, but ask to waive PSI.
Anything you wish to say on behalf of your client?
Just ask you to follow the plea bargain here.
All right. And the cause number ending in 2528, the court will find you guilty, sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 2529. Take in consideration 2023 CR 2621, 2527, 699-185 and 184. There's to be restitution, if any, to Isaac Cervantes, Cameron Carroll, Kyle Sutherland, and Stephanie Lefevre, and also no contact with any of those parties. And then in cause number ending in 2529, court is finding you guilty, sentence you to 5 years in the prison, credit for any time served, concurrent with 2023 CR 2528, taking consideration 2023 CR 2621, 2527, County Court Cause number 699-185, 184, no contact, and restitution to the following: Isaac Cervantes, Cameron Carroll, Kyle Sutherland, and Stephanie Lefevre. I'm pronouncing that name all sorts of ways. I apologize to Stephanie. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're off the record. How old are you?
17.
You're 17 and you're doing this foolishness. If you want things, you got to get a job so you can have things. You understand?
In the final moments of this hearing, the courtroom turns its attention to a 17-year-old defendant facing the reality of his choices. Sentenced to 5 years in prison, the judge delivers a stern warning, not just about punishment, but about the future. She reminds him that prison is no place for a teenager, and that the decisions he makes now will shape the rest of his life. This case serves as a powerful reminder. Age does not excuse violence, and the justice system will hold offenders accountable, no matter how young they are. If you found this courtroom moment insightful, consider subscribing for more real cases and judicial decisions.